Mr. Beneficiary, take you and your trust back to jail.
I have some questions for the clerk, Your Honor.
No. You know what? If you answer my questions, I'll consider it.
Okay. What's the question?
What's your name?
The beneficiary.
Deputy, you can remove him. He's not here.
He's not here today because he doesn't exist.
Okay, bye.
I mean,
If you're not him, then I'll issue an arrest warrant for Kevin Pollard because he's supposed to be here.
under trust law, it's a contradiction for one to be the beneficiary and trustee, Your Honor.
All right, you're talking a different language to me. I have no idea what you're talking about.
But the court does find that Mr. Pollard poses a great danger to the community, and a $250,000 bond is unaffordable, but it's not enough. The bond is going to be increased to $1 million.
His name?
The beneficiary.
Yeah, first name, Mr. Beneficiary.
Are you stating that the trust that we are administrating is the Kevin Pollard Trust? If so,
I'm asking you what your name is.
my name is the beneficiary of the trust.
Of whose trust?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor?
Okay, I'm
If so,
gonna recall him. Bring up somebody else. Put him aside.
Thank you,
We'll call him at the end.
Thank you, Judge.
Sir, is your name the beneficiary, Kevin Theron Anthony Pard? Yes or no?
I'm the beneficiary of the trust, Your Honor. Are you stating that the trust that we are now administrating is the Kevin Pollard Trust?
Are you Kevin Pollard? I'm asking you.
Is the trust that we are now administrating?
Sir, I asked the questions here. You give me yes or no answers.
You're asking for my permission
I ask the questions. You give the answers. Is that clear?
It's very clear.
Okay, listen.
Yes.
Are you also known by the name of Kevin Pollard amongst other names? Yes or no?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor? If so, Kevin Pollard is in fact present today. It is you that is Kevin Pollard, Your Honor. It is you.
Really?
Yes, Your Honor.
Really?
It is you that is Kevin Pollard. Yes, Your
I'm
Honor.
Kevin Pollard.
You are Kevin Pollard today, Your Honor. I am the beneficiary.
And then who are you?
I am the beneficiary of the trust.
Okay, well, Mr. Beneficiary, take you and your trust back to jail.
I have some questions for the clerk, Your Honor.
No.
Can I speak to the clerk before we go any further?
You know what? I'm put you in timeout. Get your mind right. Mr. Pollard?
Yes, sir. Can I have the clerk present? Please, Your Honor.
Don't give in.
Please have the clerk present in the Zoom meeting.
You know what? If you answer my questions, I'll consider it.
Okay. What's the question?
What's your name?
The beneficiary.
All right, Mr. Beneficiary, put you back in timeout. All right, Beneficiary. I'm going to give you another chance in front of another magistrate.
That's no problem. Can I have the clerk present, please?
Hey, sir, I'm Magistrate Aardea.
Excuse
DDC.
me? Yeah.
I'm talking to the DDC officer.
Yes.
DDC?
Yes, ma'am.
Okay. The gentleman that is in front of the screen, in front of camera one, what name do you have him listed as?
Kevin Pollard.
Do you have a middle name?
No, ma'am.
Okay, so you have a Kevin Pollard. Okay, and sir, you're identified as Kevin Pollard, but you're considering yourself the beneficiary. Is that correct, sir?
Are we on the record?
We are. Everything is on the record.
Okay, are you stating that the trust that we are now administrating is the Kevin Pollard trust, ma'am?
I'm not administrating any trust because there is no trust in front of me. But what I'm asking you is, you call yourself the beneficiary, is that correct?
Yes, Your Honor.
Okay, no problem. I have case number is 240-5538101. People of the state of Michigan versus Theron Anthony Pard, who
Your
is
Honor,
listed by DDC as Kevin Pollard. However, the gentleman has identified himself as the beneficiary.
You representing as Kevin Pollard today, Your Honor.
Mr. Pollard,
I'm not.
Mr. Pollard, now, as your counsel, I am going to advise that you stop speaking and allow the judge to speak.
Yes, ma'am.
Counsel Kirkland.
Good afternoon, Your Honor. Shava Kirkland on behalf of Mr. Pollard, who has been advised of his rights, wishes to stand mute and waive the formal reading.
Thank you. I'm going to enter plea of not guilty. February 2nd, 2024. It is a probable cause conference, followed by preliminary examination, February 8th, 1:30 p.m. Both matters are in front of Judge King. The probable cause conference, it is at 8:30 in the morning. Mr. Beneficiary, Mr. Beneficiary, you should not talk over to the court. I thank you very much.
You are under oath and you are on record. And I'm asking you,
beneficiary, I have not sworn you under oath. I am under oath, so I am doing all this. I'm going to enter plea of not guilty. I already given the court dates while this case is pending, sir. Okay, there should be no contact with the individual.
You are not allowed to state what the judgment is. That is my job.
Mr. Pollard, I do want to let you know that the person.
Okay.
I have a question for the clerk.
Okay.
I have a question for the clerk.
For a moment.
I have a question for the clerk.
You will give an opportunity, sir. You will give an opportunity. Let me finish. While this case is pending, there's no contact with that means no person contact, no contact with third parties, no phone calls, no emails, no text messaging. The people, go ahead, Esteban.
Yeah, the people are asking for $250,000 cash bond, no cash, no surety. If he's able to ever post bond, we'd like GPS tether with home arrest. The defendant, Your Honor, has a continuing situation where he entices young girls on the internet from Arizona in this particular case, and previously on 10/23/2023 in another case where he enticed people. He's been arrested 3 different times for criminal sexual conduct. The first case, he was found not guilty back on 5/15/2015. The 10/21/2023 case, where he was criminal sexual conduct first degree and also contributing alcohol to a minor, 2 counts of that, was at the exam dismissed without prejudice. My belief in all that is because these victims all live out of state. In our particular case we have here today, Your Honor, the victim is from Arizona. She came here after having a relationship, not the victim, but one of the witnesses came here after having a 3-year relationship with this defendant on the internet. When she turned 18, she came to visit. And also, Mr. Pollard introduced her to another girl who is also from Arizona. The other girl brought her niece or her, I forgot the relationship, but her 7-year-old niece with her to visit Mr. Pollard. And what happened then, because the person was tired from traveling, she fell asleep in the living room. When she woke up, she went into the bedroom, and there was Mr. Pollard with the 7-year-old girl. He then said, "What are you doing?" And he says, "Well, we're playing video games." So the woman, the adult in the room, she falls asleep again. And then she is awakened by the 7-year-old girl and asked to leave. The 7-year-old girl then tells her mother that Mr. Pollard touched her, rubbed her, he says, okay? He said, accidentally is what he's trying to tell us what happened. The situation is she's told, the 7-year-old child has told TED Talk that he did this. He's told Protective Services that he did this. And as far as I'm concerned, Judge, he fits the category of a predator because he did the same thing in the 10/23/2023 case of enticing young people from other parts of the country, perhaps, I don't know where exactly, to come and see him on the internet. So we're asking for $250,000 cash bond, no surety, and GPS tether if he's ever be able to post bond, Your Honor. Thank you.
Okay. One question, Council Ragnan.
Yes.
Does he have any pending cases?
Not that I know of, Your Honor. The 1023 case, 1021, 2023 case has been dismissed without prejudice at the exam, and I couldn't find out it was because if the witness was out of town or what the problem was, but.
Okay.
Thank you.
Thank you. Okay. Council Kirkland, go ahead, Esteban, please.
Thank you, Your Honor. I'd ask this court, understanding the seriousness of these charges, for a 10% bond if this court is not inclined to do a high personal bond. So one, I know the bulk of Brother Counsel's argument was this dismissed case from last year. I'd ask that this court sentence him based on these allegations and the facts and details surrounding this case. This is a 2020 case. And the woman that he met was 20 years old, or that came to see him was a 20-year-old woman, was not an underage woman. And the allegation is that she brought her, I believe, goddaughter to the home. Now, there are different variations because a couple different stories are told as to what occurred there. But Mr. Pollard has maintained that he didn't actually assault the little girl. I'm not sure why this case wasn't charged until 2024, but it is a 4-year-old case. My understanding is that he, I don't believe he's had any convictions since then. He is a lifelong resident, has a child, so he has strong ties to the community. He also owns a lawn service here. At this point, there's no amount of bond that he can't afford to pay, so even a 10% bond would be unaffordable for him. But given the age of this case and his lack of issues since this, I'd ask that this court consider a high personal bond, if not that, a 10% bond.
Thank you. I've heard the representations from both sides in this particular matter in reference to the beneficiary who is listed by the court or by DDC as Kevin Pollard, is that in this particular matter, even though this is from 2020, okay, there was a forensic interview, Kids Talk, with the victim, and she disclosed that she was touched by the defendant and that he rubbed her with his hand. This court is not considering the other cases that were dismissed without prejudice. Okay, this court is only going with this matter. In reference to this gentleman, the defendant, bond is going to be $250,000 cash. There's going to be a GPS tether, home arrest. Further, okay, it's going to be unaffordable. So today is Friday. He's going to get another court date. Today is the 26th, January 29th. 2024, 9 o'clock in front of Judge McConicole, who's going to be looking at the bond amount and bond conditions. Also, there is one other thing. This court looks at clear and convincing evidence standard, okay, based on the representation, based on the reading. This court is convinced that Mr. Pollard, okay, I'm sorry, the beneficiary, okay, that he is a creditor in this particular matter. That's why we're putting at $250,000 cash, GPS tether, house arrest. He does have the unaffordable bond redetermination for this Monday, January 29, 2024, 9 o'clock in front of Judge McConicole. Also, there's another bond condition. He's not to be around any minor children. That concludes the arraignment of the beneficiary, also known as Kevin Pollard. Madam Clerk.
Pre-trial, Your Honor.
Do you wish to talk to the gentleman that's in front of the screen?
Judge.
Okay. Just so for the record, is that the clerk has declined to talk to the gentleman in front of the screen.
No, that is not fair.
Thank you.
That is not fair. You cannot do this. Under oath and on record, you cannot do this. I have rights, and you violated them, and you was not my judge.
Okay, you go. Go ahead and do whatever.
You cannot do that.
Okay.
As the beneficiary, I asked.
I'm sorry.
Can we have those dates again? We couldn't hear them.
Over the dates.
February 2nd, February 8th.
February 2nd, February 8th. Bond redetermination Monday.
Of this QV trust account that she are.
Huh? What you say?
Yes, okay. What is the bond for your client? 250?
Cash, that's correct.
Argument.
Judge, my client's 38 years of age. He's on Social Security disability, Judge. I don't see any criminal history for Mr. Pollard, Your Honor. He lives in the city, does have a child. Your Honor, this alleged incident occurred back in 2020. So it's some 4 years ago. Obviously, it's a serious case, obviously. But it's 4 years old, Judge. He has no priors. I'm asking respectfully for a reduction in bond. The bond is $250,000 cash. Judge, I know the court will impose a GPS tether. I already know that, Judge. My client, in fact, Judge, he has a tether already on. He has a tether already on. Let me be clear about that. There's a misdemeanor, and I apologize, Judge, if I said something wrong initially. There's a misdemeanor that he has the tether for, so it's a misdemeanor.
Okay.
Your Honor. And he does a lawn care service, so he does have some work that he does, but the court doesn't have to worry about tether. I'm just asking for a reduction in bond to either a high some type of 10% bond. I think 250,000, Judge, is excessive. Thank you.
Okay. Mr. Prosecutor.
Judge, the defendant on the screen today in the top left, he's being charged with sexually assaulting a 7-year-old. The assault allegedly happened at his house in his bed. Your Honor, this is an individual who allegedly is self-proclaimed part of the tribe of Judah. This is also an individual that I actually had the opportunity to watch the arraignment regarding the defendant in this case, gave the magistrate such a hard time that multiple magistrates actually ended up having to handle the matter because he wouldn't give up his name or his identity. Now, being charged with this and now knowing what his past is like, I may refrain from giving a magistrate or a judge my name as well. Because, Judge, the situation that Mr. Reagan is talking about that the defendant's involved in right now, it has to do with selling and furnishing alcohol to minors, to a 12-year-old and 14-year-old. It actually originally began as a criminal sexual conduct first degree where the defendant allegedly was having sex with the 12-year-old. But, Your Honor, based on apparently the idea that somebody didn't appear at a hearing, it was reduced to the selling and furnishing of the alcohol. So he has an ongoing matter right now, Judge. He's on bond. We have this particular matter, allegedly, where this individual ended up touching a 7-year-old's vagina. We have corroboration to that, Judge. And, Your Honor, with all due respect, the way that the people see this defendant based on previously being charged, now being charged with another CSC first degree, we find him to be a predator. Not only that, Judge, we find him to be mentally unstable. He's currently on a case regarding minors, 12 and 14 years old, and just plain and simple, Judge, we find him to be a danger to the community. Therefore, Judge, we do feel as though a high cash bond is appropriate. We do feel as though the magistrate got it right here in terms of the $250,000 cash, not just to this particular complainant, but kids, all kids. This is one of those individuals where we feel as though he poses a danger to everybody.
See, where we haven't heard the arguments of counsel, where this gets a little dicey for concerning bond is that we have a situation where the defendant allegedly, I guess an 18-year-old comes in town to visit with him for her birthday. She turned 18, so she comes to see the 37-year-old. Who she's been in a long-term relationship with for the last 3 years. So I guess he would have been 34, starting the relationship with the 15-year-old. Allegedly, she talks to a friend and they come over and the 7-year-old is over. The girl comes and finds the two of them in the bed, and then the mother contacts a person asking who is this Kevin guy, because her daughter says he touched her vagina. So, and then we have another case of furnishing alcohol to 12-year-olds, and whether there's sex there or not sex there, we have a pattern that's a little bit concerning. It's a lot of minors, a lot of alcohol, a lot of sex allegations, a lot of molestation allegations, a lot of flying people in who are kids and teenagers, and so we're real concerned about this. So the $250,000 bond is an unaffordable bond, and so the court does find that this defendant is a danger to all kids. He's just a danger. The court is going to disagree with the magistrate on this, and I know the magistrate or magistrates had some issues with this defendant, and they used the information that they had at this time to come up with the $250,000 bond. But the court does find that Mr. Pollard poses a great danger to the community, and a $250,000 bond is unaffordable, but it's not enough. It's not enough. So what we're going to do is we're going to add some to it to make sure he's incapacitated. But if he posts the bond, then that means we know that he'll appear for court. So the bond is going to be increased to $1 million, and that'll be $1 million cash. If he makes the $1 million, then he'll be placed under house arrest with GPS tether. And Mr. Pollard is not to have any interactions with anyone under the age of 18. Whether they're family, whether he knows them, he's not to be around anyone under the age of 18. If he is, that will be.
Sovereign citizen arguments often rely on separating the living man from the legal identity, but once that position becomes public, backing away feels like admitting defeat. The strategy may feel consistent to the defendant, yet every refusal to engage with normal court procedure reduces credibility while the court keeps making legally significant decisions.
Violate this bond. Thank you.
So Judge, the bond was $250,000 cash.
Yeah, and now it's $1 million cash. Now it's $1 million cash.
Okay.
It's $1 million now. It's $1 million now.
Okay, because he's on Social Security disability now. Can't afford
I understand, but the court finds that Mr. Pollard, it may be some serial actions going on right here, and I don't really know if he's like a serial rapist. I don't know if there are other children that he just lays in the bed with allegedly and touches, or there's other 12-year-olds, or if he's flying other 18-year-olds out to celebrate their birthday. I'm not sure. So what we have to do is we're going to err on the side of caution and make sure Mr. Pollard is not able, at least right now, to be able to engage or even be charged with engaging in these type of activities.
Yeah, no, Judge, I get it. I know it's rough when the allegations are from January of 2020, but the prosecutor doesn't charge until January 24. I mean,
Yeah, it's when it looks like it wasn't until October 14th of 2023 when the mother called asking who is this Kevin guy. So we just kind of got that information, and I'm not sure when the 12-year-old. I'm not sure when all the 12-year-old and the alcohol when that happened. So it's a lot, Mr. Reagan, and so the timeline may get a little bit jumbled. But it's a lot of kids, teenagers, alcohol, sex, molestation. It's kind of blending, and so we're here where we are.
Yes, sir.
Right, thank you, Mr. Pollard. You can leave.
Judge, I just spoke with Ms. Moses. She's not available to Zoom in right now, so I can stand in.
Okay. Yes, we're ready on Pollard.
Calling case number 2405-538-101, people in the state of Michigan versus Kenneth. Defendant charged with count 1, sexual conduct, second degree.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249. I'm standing in for the attorney of record, Assistant Prosecuting Attorney Erica Moses.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Pollard. My P number is 58961.
All right. What's your pleasure, counsel? Oh, Mr. Pollard, unmute yourself and tell us your name, sir. Mr. Pollard. Have them unmute you so you can tell us your name. Tell me your name, sir.
I exercise my right to remain silent.
You don't want to tell us your name?
I'm the beneficiary.
Beneficiary of what?
Of the trust that we are now here to administrate.
Okay, that's fine. Can you tell me your name?
Excuse me?
Can you tell me your name?
The beneficiary of the trust, Your Honor. I'm not
beneficiary of trust.
I'm not summoned here as the name. I'm summoned as the state trust. It'll be a contradiction.
I'm looking for Kevin Pollard. If he's not here, I will capious him.
Your Honor, you are appearing as Kevin Pollard today.
No, I'm not. My name is Kenneth King.
No, Your Honor, you are the trustee of the administrator, the trust that we are now here to administrate. It is a
I have no idea what you're talking about, sir. I'm just looking for Kevin Pollard. If you're not him, then I'll issue an arrest warrant for Kevin Pollard because he's supposed to be here.
Under trust law, it's a contradiction for one to be the beneficiary and the trustee, Your Honor.
All right, you're talking a different language to me. I have no idea what you're talking about. Miss James, how would you like to proceed?
Judge, originally I was going to ask it to be set for a preliminary examination, but it sounds like it may be a competency issue. So Judge, what I'm going to ask the court to do, I have an appointment to meet with Mr. Pollard this afternoon. I'm going to ask the court if you would, we can set an exam date, but we could also set Monday as a review date.
Hey, why don't we just do that before we set an exam date?
Okay.
The court will adjourn the probable cause conference. If you're able to find Mr. Pollard, we'll adjourn the probable cause conference to February 5th at 8:30.
Yes, Your Honor.
If you find Mr. Pollard, then I will issue a capious for his arrest.
Yes, Your Honor. Thank you. Have a good one, everyone.
Sir, in Wayne County Jail, what's your name?
There you go.
Say your name.
Say your name, sir.
Who, me?
Yeah.
The beneficiary of the state. I'm here today for the state.
What's your name, sir? I don't know who the beneficiary is.
Excuse me?
What is your name?
I'm coming to appear as the beneficiary of the state, Your Honor.
Okay, forget all that. What did your mom call you when she named you? I have no idea who you are, sir. Okay, well, you're gonna sit there until I figure out who you are.
I'm not under that jurisdiction to consent to the name, Your Honor. That's appearing under your jurisdiction.
Your case then, because I'm looking for Mr. Pollard. If you're not Mr. Pollard, then you're not here, and a warrant will be for your arrest, and you can sit in jail till you rot for all I care.
That's fine, Your Honor, but that's
Deputy, you can remove him. He's not here.
He's not here today because he doesn't exist.
Okay, bye.
The all caps entity.
I'm talking to you. Goodbye. Ms. Drain, I have Ms. James here on Pollard. That said you were standing in for Erica Moses.
Yes.
Okay. Ready? All right, ready on Pollard.
Calling case number 240-55381, the people of the state of Michigan versus Kevin Pollard. Defendant is being charged with count 1, criminal sexual conduct, second degree. Person under 13, defendant 17 years of age or older. So notice today is the date and time for
appearance for the record, please.
Good morning, Your Honor. Shelley Drain for the people, number 60249.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Pollard. Judge, I would ask to waive his presence if he is not in the courtroom. He is in the Wayne County Jail.
Court away the defendant's presence. Today's the date time set for a competency hearing. Did we get anything back from the forensic center?
Yes, Your Honor. The report indicates that Mr. Pollard is competent.
Are you stipulating to those findings?
I am, Your Honor.
Okay, the court makes a finding that the defendant is competent to stand trial. What's your pleasure?
Judge, we would ask that it be set for a preliminary examination date.
Court will continue the plea of not guilty and set this matter for a preliminary examination. How is March 27th at 12:15?
Judge, I'm out of town all next week. My first available date would be April 4th.
That's going to be a problem, Mr. James, because the court is, that's my homicide day. The court is closed April 5th.
Okay. Well, Judge, I'm out of town all next week, and then April 1st, 2nd, and 3rd, I'm in a trial in Ann Arbor.
April 8th, that's my last offer.
April 8th is a good date.
April 8th at 10 o'clock.
10 o'clock, yes.
Bound to be continued.
Okay. Thank you, Your Honor. Have a good one, everyone.
How you doing, Mr. Pollard? Yes, sir. Thank you. He's not finished yet. Just to order next to your time.
Calling case 2455381, people of the state of Michigan versus Theron Anthony Pard. Defendant is charged in count 1, criminal sexual conduct, second degree, person under 13, defendant 17 years of age or older. Appearances for the record.
Thank you, Your Honor. Erica Moses on behalf of the people, 78491.
And good morning, Your Honor. Nicole Johnson from the hearing on behalf of Mr. Pollard.
Kevin Pollard.
All right, today's the date and time set for preliminary examination. Are the people ready to proceed?
Your Honor, I am not. I contacted the court via email as well as Ms. James to let the court know that Ms. Alexander Grayson and her daughter Nayla are out of state this week. They will be back on Friday. She said she'd be available then or anytime next week, Your Honor. And I do apologize. They are on board prosecuting. They will be present. They just cannot be present today as a short term.
Judge, I will indicate that we were last here on March 20th, and the preliminary exam date was set on that date. I would indicate that the prosecutor did send an email out on Thursday. Judge, I do not believe that is good cause. This date has been set for some time. I would ask the court to dismiss this case without prejudice.
Wait a second. All right. So I want to make sure Mr. Pollard knows exactly what's going on here. So Mr. Pollard, when this court set the date for the preliminary examination, that date was set without the people contacting witnesses at that time. Sometime after you found out and the witnesses prepaid the trip on the time. Although they're not here, they are interested in going forward with this. So this court can find good cause to adjourn the matter to the date that they're not back or otherwise unable to proceed the case. Court also has the option of dismissing this matter right now, but because people indicated that they have complaining citizens that are still interested in going forward with this matter. Case will likely be reissued, which means we could be rearrested again, and we have to start this process all over again. I look at your face, I know you don't want that either. Yes. So I'm inclined to go ahead and give them to Friday to present their witnesses and go forward. If they're not able to do so, in this case.
Judge, I'm not available on Friday.
No time Friday?
No, Judge.
I can do it.
16th or 17th?
Excuse me?
The 16th or the 17th?
Can't do the 16th, that's my homicide today. Not available on the 15th.
Judge, I have a full docket on the 15th. One of the reasons is because I have a jury trial set for tomorrow, so I have to fire on everything.
Okay, we can do April 17th at 10 o'clock. We'll find a good cause for the adjournment.
Thank you, sir.
On case 2455381, for the state of Michigan versus Kevin Theron Anthony Pard. Been discharged in count 1 criminal sexual conduct, 2nd degree. Person number 13 is in 17 years of age or older. Prosecutor, right here. Okay. Mr. Powell, we're going to have you have a seat in the second row until the witness comes in.
Sure. Chill, sir.
Did I get the appearances already?
Thank you, Your Honor. Erica Moses on behalf of the people from 78491.
And good morning, Your Honor, Nicole Jones, on behalf of Mr. Pollard, P5896.
Mr. Powell, tell us your name for the record.
Stand up.
Tell us your name, sir.
Stand up.
There's a date time set for preliminary examination. Are you ready to proceed? She be on again?
She went to get the young lady
Let's
first.
get her some roller skates. Are you people ready to proceed? It looks like it.
Yes, Your Honor, if I could just have one moment.
What are you doing? This, sorry.
Just before we began, she wanted to make it easy for she could ID anybody, otherwise she wasn't going to begin. So she just wanted to look around first, and now she's in the question.
Thank you, Judge.
Hello.
May we approach one moment?
Okay.
Uh-huh. See you around 9.
Okay, we're back on the record.
Thank you, Your Honor. The people did have one witness here, the complainant in this matter. I do have an issue moving forward at this time. I do plan on rewriting. However, I need to get an out-of-state witness here in order to proceed.
With that in mind, we would ask this case be dismissed.
So order the court will dismiss this matter without prejudice.
Judge.
Dismiss the court, Mr. James?
Yes, Your Honor.
This series shows two separate legal tracks moving at the same time. One track is the courtroom process, where judges focus on bond, public safety, scheduling, and whether the legal requirements for each hearing have been met. The other track is the sovereign citizen strategy, where identity, jurisdiction, trusts, and beneficiary language become the center of the defendant's attention. Those two tracks never truly meet. Throughout these hearings, the court continues making decisions based on established criminal procedure rather than arguments about a separate legal identity. That is an important lesson viewers often miss. A jurisdiction challenge only matters if it has a recognized legal foundation. Repeating trust language or refusing to acknowledge a legal name does not stop hearings, pause deadlines, or prevent judges from issuing orders. The most consequential decisions in this case were not created by dramatic exchanges. They came from judicial findings about community safety, bond conditions, competency, and procedural requirements. Those decisions carried immediate legal effects regardless of the defendant's chosen strategy. The ending also highlights another reality of the justice system. A dismissal without prejudice is not a declaration that allegations were false. It reflects a procedural outcome at that stage of the case, leaving open the possibility that the matter could be brought again if legal requirements are later satisfied. In the end, this case demonstrates how procedural law, not courtroom rhetoric, determines what happens next. While sovereign citizen concepts may dominate the defendant's approach, the court continues evaluating evidence, legal standards, and public safety under ordinary criminal procedure. Sometimes the biggest turning point in a courtroom isn't the loudest argument. It's the procedural decision that quietly changes everything.